Hey y'all, I'm looking mighty crazy. But y'all just saw my gym video of me doing my step class, so you can see exactly why. As you can see, I'm back in the gym on Tuesday. It was canceled last Tuesday because of Halloween, so I'm back in the swing of things. I'm bouncing on a what do you call this ball? One of those balls you work out with. I'm waiting for y'all to get in here. It's Random Tuesday. Random Tuesday. Where y'all at? Gee, what's going on? I'm gonna be quick. I'm not gonna be long. I'm gonna give people a chance. Tracy, how you doing? Mark, Cousin Thomas. Yes. So I don't know if you guys got a chance to look at the article that I posted about this country band called Trick Pony. So they're currently embroiled in a long, I guess, trademark dispute with their former manager. And so basically what it is, from what I read in the article, is that, I pull my earring out, this group has been operating with this name. I don't know if they have an operating agreement or what, but that's part of what I'm going to talk about with this Random Tuesday. But anywho, at some point, the law firm that actually registered their band name failed to let them know that they had to pay maintenance fees. So, if you've been following my trademark series that I've been talking about, when you get a trademark and it's registered and everything, yay, it's been approved. Every so many years you have to pay maintenance fees. And so if you do not keep up with those maintenance fees, you can actually lose your trademark registration. And it can be what's called abandoned. So as I've said before, trademark is not an absolute right. If you are not using your trademark or you don't keep up with the fees or anything that they require of you, anybody can come behind you and pick it up. So I don't know what the status of, the relationship between Trick Pony and their former manager, but for whatever reason, the law firm that was initially involved with the filing of that particular trademark later allowed this manager to file a trademark application, or same thing, trademark application for the same name. And so he registered it under an LLC company that he started. So from the article said that his argument was that he wanted to use this name, I guess, for another band based upon monies that he had invested in the group. So unbeknownst to the group, they had no idea that he had done that, but before they knew it, they had received a cease and desist letter from him saying, hey, you cannot use this name anymore. And so the biggest argument within that case, first of all, was the law firm, whether or not they acted in bad faith by allowing him to do that. Secondly, who were they representing? Did they represent the band, or did they represent the manager? So at some point, the judge in that case actually found a conflict of interest, and I think he removed the counsel from that case because they had been involved in too far in the process, where you had them representing the band, obviously, for filing the trademark, and then later on representing this manager and basically taking the name from under them. His argument was that, of course, that the band broke up at some point, and so that gave him the ability to do that, which I think is still ridiculous depending upon how long that was. Or, I mean, even if there was bad blood, I kind of feel like he should have reached out to them and said, hey, you guys, I'm getting ready to, trademark this name, something. I don't know what the situation is between the manager and the group as to, what led to the manager not being the manager anymore. But when you're an artist, you're in music or anything, it's expected that you're going to change managers quite often, especially if they're not, depending upon when they started with you in your career and where you're trying to take your career later on in life. So a lot of times you do change managers quite frequently. So the other point about this particular Random Tuesday is about bands. When you're operating as a single artist, you don't have the same concerns that a band would. I still recommend that artists treat their music like a business. So usually when I speak to, you know, an artist just getting started, the first thing we do is we set up an LLC or some kind of business structure that will maintain all of the music. Everything will be registered in the business name. It won't be registered in the person's name, because you always want to keep your business separate from your personal. You never know what happens. I mean, you work with other producers and things of that nature, and of course you expect people to give you things that they actually own. But for whatever reason, let's say that a producer gave you a track that he did not own, and then later on you're being sued for it. You would want to be sued under the business versus being sued under your personal name, because then what happens is they can come after personal assets versus just the business assets if there is no money, whatever the case is. So you always want to keep, when you are separating your business from your personal, it's more than a hobby to you. You're actually trying to make money doing this. Then you should have a separate business structure set up to provide you with that cushion. As long as you're maintaining your records and you're keeping things separate, you should be okay in that instance. So usually if I have a single artist, they don't necessarily have to worry about additional paperwork that addresses how, who owns what, who's responsible for what fees, who does the registering of your copyrights, who does the registering of your trademark. So a lot of times, again, you want to have those things addressed, because it's all good when things are good, and then till something goes bad. So when something goes bad, one of the group members leaves the group, and then next thing you know, they decide to start another band with the same name. Well, who owns it? If you haven't addressed those things in your operating agreement, there's a likelihood that if they've been using that name along with you, they were a key member in the band, it's a possibility that they can turn around and use that name. I don't know if you guys remember from the Temptations movie, there was actually an incident between some of the band members where one of the lead singers was operating as Temptations featuring, I forget what his name was, and then there was another Temptations, and I'm assuming there was some kind of dispute between them in court, and the court basically said that both of them can use that. So to avoid those kinds of issues, what you need to do is have some kind of operating agreement that says, if you leave this band, you leave this group. Meaning this name does not belong to you, it belongs to the band. So that no one can just separately go on their own and do their own thing. Hey, Sandy. What's another instance? I believe there was a big dispute between the members of En Vogue. They had a similar issue where they were fighting over the En Vogue name. And who was allowed to use it. Eventually, I don't know if you guys ever have a chance to look at En Vogue, the current group members now, they're the ones that were awarded the ability to use that name. It's a possibility that they bought out the other members. And who else? I can't remember. Oh, TLC. So another instance with TLC was that TLC wasn't involved in any of their paperwork. Their manager handled everything. But if you're not looking at that paperwork, you don't know who is registered as what. So when the band decided they wanted to get rid of the manager, Pebbles, little did they know, Pebbles had everything registered in her name. So even though they were operating under that name, they were literally operating as her employees in a sense. So they had to buy back their name from Pebbles. And I'm pretty sure she charged them a pretty penny to do that. So those are just some of the things that you need to address, and I would like to assume if Trick Pony had some kind of operating agreement that would have been, that could have been avoided in terms of when this manager left, he wasn't, allowed that ability to do that. Secondly, the other issue is, and this comes up for me a lot. A lot of times clients come to me via their managers, and so a lot of times the managers act kind of territorial of the client. So for me, I have to keep making sure that I keep it separate of who I actually represent. I don't necessarily represent the manager, even if he paid for it. I represent the group, or I represent the client. That's happened to me several times where, the manager was acting as the middleman, but you have to make sure that you're advocating for your client's interests. And I kind of feel like the law firm involved in Trick Pony was more concerned about the manager than they were with the actual group. So a lot of times we have those lines blurred in those types of situations. So we as attorneys have to protect ourselves and say, okay, you know, you might be paying the money or whatever, but this is who I represent. I mean, it happens in the criminal aspect all the time, where you have one person paying for the attorney, but the attorney actually represents the client, right? So the client being, let's say we have a situation where you have mom who's paying for the lawyer for her son or whatever the case is. The attorney actually represents the son, not the mom. But a lot of times mom will come bursting into the office and, hey, I want to know what's going on with my son's case. But technically they're not supposed to answer any questions for mom. They're supposed to answer questions for the son. But lines get blurred depending on who's paying for what. So, you know, when you're in a band, you need to address those issues. Who owns the equipment? Are you providing your own equipment? If you're traveling on your way to a gig for the band and something happens, are you going to be sued personally? Are you going to be sued under the band name if you have one? So it's just kind of some things that you need to think about if you're in a band. I recall maybe back in, I want to say January, I was dating briefly a gentleman that was in a band, and my lawyer brain started working, and I asked him some questions like, well, do you guys have an operating agreement? And he's like, no. Well, what happens if you leave the band? And he just kind of looked at me dumbfounded. But I guess that's just my lawyer brain. All the time I'm, you know, wondering if people have addressed these issues, because again, it's all good until it's not. And then next thing you know, you have people fighting in court, and what happens is when you don't have those things in place, you have to, the court is going to go by what's fair. They're going to, you know, look at all the evidence, and all of those things can be avoided if it's addressed in some kind of agreement that says, hey, this is what happens if you leave. This is what happens based upon these facts. I've looked up several different groups that all have some kind of separate business structure, and I'm pretty sure all of their trademark, their invaluable intellectual property is registered within that entity. So for instance, NSYNC has they're incorporated under, it's called Zeeks Incorporated. And then Backstreet Boys, they have their own entity. It's called BSB Incorporated. So again, these groups, you know, when they get together, they're operating as Backstreet Boys. Same thing with NSYNC. None of them can go outside of those groups or whatever and get other members and then all of a sudden call themselves NSYNC, because they probably addressed it in whatever agreements that they have with each other, that we only come together as a group and we use NSYNC. Nobody can just go outside of the group and use NSYNC, or nobody can go outside the group and use the name Backstreet Boys. Hey Darrell, how are you? I'm just basically talking about issues that can come up when you're in a band. Other major issues becomes like if you're somebody who plays the instruments in a band, but then you have one member in the group that writes the music. Are you going to share in the copyright, the underlying composition, or are you going to be sharing only on the sound recording? Those are things that, what were we going to say? Sounds like what happens with probate. No will, the state courts decide. Exactly. So if you don't have some kind of agreement that says how you're going to decide things, the courts are going to look to, you know, their default law of how these things are handled. Or again, in the instances of trademarks, it gets even more trickier, because again, whose name is it registered in, even though you guys are operating under it. So yeah, I just thought that was a very, very interesting case, and it felt like something that we needed to discuss on Random Tuesday. I've completely gotten away from copyright, but I couldn't pass up talking about that particular case. So if you guys are interested, I suggest you guys look it up. I did post it, but so I'm thinking that case is going to be in court for a little while, just because. And then I'm wondering if something might happen to the law firm, because I do feel like they operated in bad faith. And first of all, not informing the client that, hey, you guys, you need to, you know, get ready to pay maintenance fees. I did take the liberty to look up the actual filing that's on TrickPony as of right now, and it is still registered in the name of the manager. And I'll post a picture of it in the comments. The case is a group. It's a country band called TrickPony, and they are in a trademark dispute with their former manager. His argument is that at some point the group broke up, and so they weren't using TrickPony anymore, and so their law firm that actually helped them get the trademark for their band name did not inform them that they had to pay maintenance fees, and so the trademark was abandoned, or it was, taken off the register. So the former manager came behind them and actually registered the name, and he claimed that he was going to use it for some other band members, claiming that he had spent a lot of money investment into the group. And the same law firm helped him to do that. And so the courts are looking at whether the law firm acted in bad faith, first of all, for not informing the client, and secondly, for allowing the manager to do that, considering they were the ones that represented the group in the first place. So it's a big mess. It's actually jumped from 2 courts. It went from one federal court to another federal court somewhere in Tennessee. So again, these are just issues you want to address. And I don't know the situation between the manager and the group and whether or not what he's saying is true in terms of the group leaving. But that is something that you need to keep in mind too. If you don't use your trademark, you can lose it. And so anybody else can come behind you and take it, even a former manager that you might not be getting along with. So of course it sounds shady, but legally what he did wrong remains to be seen, because if the group was not operating using that name and they weren't working with him anymore, was he allowed to do it? The only issue I see that's really big there is the fact that the law firm was involved with both the group and with the manager, and by them representing the group, do they have a responsibility to say, hey, you guys, this trademark is no longer valid, there's a possibility your manager is trying to take it. Like, who did they owe a duty to? So, yeah, that's a really, really big case that I think is, going to set a precedent, I think, in terms of, well, not so much in trademark, but in terms of, our responsibilities as lawyers. When you have, a manager contacting you on behalf of the client, but then at the same time wanting you to do things for them that goes against the interest of the client. Who do you represent? So I guess it's going to keep me on my toes too, because I'm going to make sure that I say, hey, manager, yes, you hired me, but I represent the client, that I represent the group, or I represent the artist. I don't represent you. So if there's ever a conflict of interest, you're going to have to find your own attorney. I'm not going to allow you to underhand a client that I work for. It's just kind of really underhanded on their part. So as of this point, like I said, the courts have found a conflict of interest with that particular law firm. So I don't know what's going to happen going forward. But I'm going to be watching that case, and I'll give you guys an update. So I am going to continue doing Random Tuesday, but I'm going to add a Random Wednesday. So Random Wednesday will be from my business page. I'm going to keep Random Tuesday on my personal page because that's where I started it. I kind of feel like I can look crazy on Random Tuesday in front of my homies, but I want to look professional and kind of polished when I do it from my biz page and actually go through the whole spiel of saying, hey, this is attorney EJ Lee, blah, 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 blah. So you would think, but that's what I'm trying to figure out. Like, I don't know what this law firm was thinking about when they allowed him to do that. It's just crazy to me. But I mean, we've heard crazy things all the time, so it's not like it's out of the realm of possibility that people would be underhanded, depending upon who paying the money. At the end of the day, a lot of these law firms, unfortunately, it's about the bills at the expense of the clients. So, but again, if you are a band or even an artist, when you're working with different managers and things, you need to have agreements that say, you know, what's going to happen with what. It shouldn't be to where a former manager can come behind you and take your invaluable intellectual property. But that's basically what happened in this case. So in their free agreement in terms of what? Like who they represented, or I think they at least owed a duty. Well, I don't know. Depending upon how many clients you have, it's probably, you know, very difficult to keep up with, you know, the maintenance fees that come due for your trademark. That probably maybe should have been the responsibility of the group. However, I don't think I would have helped the manager to turn around and get the trademark from under this group, knowing you represented them to file the actual registration and for it to go through. That's where I feel like things got tricky. Hey Danielle, you can probably catch the replay because I'm almost done at this point. But yeah, I'm gonna post a picture of the actual filing that's on there now in the comments. I took a screenshot of it. It's so tricky because if what he's saying is true, like if the group broke up, then what? Is the law firm still supposed to say, hey, you guys, I know you guys aren't together anymore, but there's maintenance fees that need to be paid. Secondly, if you're not using the name, you're effectively abandoning it anyway. You have to maintain continuous use of that trademark. So you can't just pay the maintenance fees and continue on like you're not a group anymore. Because then that means you're not using it. That's what trademark is for. It's not an absolute right that you sit on. You can sit on copyright all day, but you can't sit on trademark. You use it or you lose it. So what I'm saying is what the manager did was shady, but was it legal or illegal in terms of, because he was tied to the group is what makes it bad. And maybe he should have got a different law firm to do it. So at that point, it would have been, the law firm's job to say, we can't do this for you. You're going to have to find another law firm to at least to avoid the appearance of impropriety on their part. Hey, Cara. I'm gonna post a pic of the Trick Pony filing, and that's the other thing I like about the USPTO website is that you can pretty much search all kinds of records. Like I've searched records on like so many different artists. Like I just wanted to see what kinds of trademarks they had registered. So I've looked up Beyonce's trademarks. I've looked up, like I said, NSYNC. I looked up Backstreet Boys. I looked up Taylor Swift. So all of those are public records that you can actually search through and see like how they registered these things and the different international classes of protection that they have actually claimed in their filings. So it actually keeps me sharp to say, okay, these are the ones that I know I need to recommend to my clients when they're doing their trademark registrations for the band names and things of that nature. So, but I will always say, again, if you're an artist or a band, you need to have some kind of agreement that says how you're going to do things. It gets more complicated when you're in a band versus being, just a single artist. And I just think a lot of times she has it for Beyonce. And it's covered in 41, 25, and 41 is entertainment, 25 is clothing. So clearly she has one for Ivy Park at this point, so I'll look that one up. And when Coach decided to change the name, I looked up those filings too. So they currently have 10 intent to use applications for Tapestry. So it's really interesting to look through those files. I even looked up this group that I loved a long time ago when I was a kid. They were called Immature. They don't actually have a filing for their name, and I was surprised. Even the name that they changed it to, which was I Am X, they don't have one for that either. I guess because they're not doing the group anymore at this point, so maybe that's why. So yeah, unless you guys have any questions about that particular case, like I said, I'm going to post a pic of that particular filing, and I'm going to be watching this case. So I'll do a Random Tuesday update on, how things play out. I think the biggest issue in that case is being able to for him to prove whether or not the band members actually abandoned the trademark. It's the group members it's a guy and a woman. I don't know if they're related or whether they're just friends and decided to start a band, but they've been using this name for quite a while, and then for whatever reason he claims they broke up, so I don't know. So, but it's a really, really interesting case because again, whose name was the trademark registered in to begin with? Was it in the band name? Did they have some kind of operating agreement that says what, who owns what, blah 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 blah? So just something for people to think about if you're in a band. I'm not trying to I'm not trying to get people all shook up, but I know when I was talking to that gentleman that I was dating and I mentioned those things to him about, well, what happens if you guys leave the group? And he kind of just looked at me dumbfounded. So that shows me that if something happens to the band, like I said, things are all good until they aren't. It's as simple as that. Especially if you haven't done any original music yet. If you at this point, I think they were just doing cover songs. They hadn't done any original music. But if you ain't looking at the paperwork and you're not asking questions, you'll look around and you don't own nothing. So, well, all right, you guys, my son is about to like lose his mind because I'm still here at the gym. So I'm going to head out. But if you guys have any questions, post them in the comments below. Again, I was talking about trademark as it relates to the band Trick Pony. And I'll post a pic in the comments. And I will see you guys later. I've done so many random Tuesdays. I don't even know what number this is. Hilarious. At all times, T. All times. But it's, again, you know, when people are, you know, doing music, they're so excited. Yeah, music, blah, blah, blah. Then no one thinks about, you know, again, protecting yourself. But that's what your lawyer is for. You know, a lot of times they want to involve us when it's too late. And you're like, well, you could have saved yourself a whole lot of money if you had involved me in the beginning to address these issues than involving me on the back end. It's about being proactive instead of being reactive. Reactive is always worse. And it's going to cost you a whole lot more money than if you had just said, okay. But then at the same time, there was a law firm involved, but they just shady as all get out. So we'll see how that plays out. But I will see you guys again. Tomorrow I'm going to do Random Wednesday, and I'm going to go back to talking about the copyright series that I keep saying I'm going to finish, but I never do. But that'll be for my biz page. So I will see you guys on the next Random Tuesday.